Hey guys, my name is Jacob Blizzard. I'm a board-certified criminal law and criminal appeal specialist attorney. I want to talk to you guys today about what exactly is involved in the appellate process. Well, first off, you kind of have to make a division right up front that an appeal is what follows directly after your conviction. So you stood trial and then you are appealing that conviction to the next higher court. It's going to be one of 14 District Court of Appeals in the state of Texas. Then after that, you could potentially go up to the Court of Criminal Appeals. Besides the appellate process, you can pursue what's called a petition for writ of habeas corpus. That comes later, and that's not what we're talking about specifically today. Today, we're talking about a direct appeal following immediately after your conviction. So, what is an attorney doing for you in that appellate process? Well, basically what happens in a direct appeal is you file a notice of appeal in the trial court. That starts the appeal process, and that clerk in that district court notifies the District Court of Appeals above that court. So it's divided into the state of 14 districts, and so it depends on where you are regionally of where your case goes. And then the clerk prepares a record, which is all of the motions, the indictment, the orders, the jury charge, the judgment. All of those things go in what's called the clerk's record. And then a court reporter that was present at your hearings and at your trial will prepare a reporter's record. And that's also filed in the Court of Appeals. Once the Court of Appeals receives those records, they issue a briefing notice. And what the appellate attorney is doing is the appellate attorney gets those records and goes through them to determine what the issues are to assert in your appeal. So appeals are asserted by issue. If you think about it in terms of something like issue statement, whether the evidence was sufficient to convict the defendant of sexual assault of a child. And then there might be, following that, a legal analysis of what the evidence was and how the evidence was insufficient. So there are a number of, quote, issues or grounds that you can assert on appeal, and they range greatly. I could never list them all to you. But the types of things you're looking for are sufficiency of the evidence. Is there enough evidence to legally convict you of a crime? Is there an error in the jury charge? Was the jury instructed correctly on the law? Or did the judge make an error in instructing the jury? Were there objections that your lawyer made to the government's evidence in your case? And if those objections were overruled, those are what's called preserved for appeal. And so you can appeal those as issues. So it might be that the state offered a hearsay statement, for example, and your lawyer objected, hearsay, objection, hearsay, and the judge said overruled. And so that preserved that error, and so now you can assert that in your appeal and say whether the trial court erred in overruling defendant's hearsay objection. And then you would go through the legal analysis and you would provide why it was an error and why it harmed your case. And so all of those things are done by what's contained in the record. So as we were talking about, sufficiency, jury charge, objections, and then also any evidence that you wanted to get in that the state objected to that wasn't allowed in. So say your attorney called a witness that wanted to testify as an alibi witness, and somehow the evidence was excluded because it was overly prejudicial, or there was some other ground that the judge decided the evidence wasn't allowed in. The Court of Appeals will also review that evidence to say whether it was an error for the district court to not allow that evidence in. So those are the kinds of things you're looking for. You're looking for things contained within the record. There are things that are much more complicated that you could get into, such as perhaps constitutionality of a statute or a search, using statements that were obtained in violation of the Constitution, things of that nature. So there are lots of different grounds, and so what an attorney does when they're going through this process is they review the clerk's record, they review the reporter's record for all of what are called the preserved errors, as we talked about. There was an order from the court denying you relief in some way, and so the Court of Appeals is going to review that. And so what the lawyer does is he's going to look through all of that and determine what things that he believes that the judge did wrong in light of what's called case law. And case law are just other cases just like yours that have happened before yours that were interpreting other situations which may be similar to yours. If we go back to the illustration from earlier, hearsay statement is made, an objection is made, objection, hearsay, overruled. Well, there's going to be cases of many different kinds that have come before yours that have dealt with the issue of hearsay, when hearsay is allowed, what types of evidence is allowed, is it harmful? And so a lawyer is going to go through and look at those cases that relate to the issue that you're thinking about presenting and determine if it was in fact an error for the judge to overrule the objection. And then they're going to think about, was it harmful to you in some manner? A key element of a good appeal is not just a wrong decision by the judge, but that the decision harmed you in some way. So effectively, that hearsay statement that was allowed in more likely led to your conviction. And so you would appeal that ground or issue. The appellate lawyer is limited in the brief of how many words can be in it. And so you can't just assert every single possible issue that you could ever think of. You have to be selective. You have to determine which issues you think are most important and which are likely to give you the greatest relief. And so here, the appellate attorney is going to make those determinations and then write the brief, and then the state gets to respond to the issues that the appellate attorney brought forward. So if the appellate lawyer brings 3 issues, the state then responds to those 3 issues, and then the Court of Appeals would decide whether or not the case should be resolved just on the briefs, the writings that were done there, or if they would submit it for oral argument. If it's submitted for oral argument, it's kind of like you may have seen on TV or heard about on the news where lawyers go before the Supreme Court and they argue a case. Well, the same thing happens in all the courts of appeals where you go and you argue your case, and you get about 20 minutes to present your brief and your argument related to your brief to the judges in person. The state gets to respond, and then you get a little bit of a reply, and then it's submitted to them. The Court of Appeals then issues an opinion. An opinion is basically a decision with an explanation as to why their decision is what it is. So in most circumstances, they make a decision and they explain the grounds that you asserted and their legal analysis of your claims that there was error in your trial. And they'll make a decision regarding that, and if they overturn your conviction based on your errors asserted in the appeal, then they send it back to the trial court for a new trial, or they could acquit you of the charges depending upon the issues. Then, if that's denied, of course, you can do a petition for discretionary review and further appeals down the road. But for the most part today, we're talking about what's done in the first level of appeal. And that's essentially what your lawyer's doing when you hire a lawyer to do a appellate brief for you or handle an appeal for you. Is they're taking these steps that we've talked about today. So being a quality writer, being a persuasive writer is very important. Being able to recognize those issues is very important. And so that's why you want to look for an attorney that has a good quality experience and potentially board certified or other relevant experience that will help you pick a good lawyer. Thanks guys for watching. If you have any comments or questions, feel free to post them below and I'll get back with you. Thank you.